Hello and welcome to the CIPD Annual Employment Law Update. Firstly, thanks to everyone who's joined the webinar so promptly. I'm Andrea Gibson, the Business Development Manager here at Muckle, and I'll be moderating the webinar today. For those that don't know Muckle, we're a leading top-ranked commercial law firm in Newcastle upon Tyne. Our clients span the UK and increasingly overseas, and we're known for providing practical legal advice. I'm joined today by your presenter, Chris Maddock, and he's a partner and he heads up our employment team. Before I hand over to Chris, I'd just like to go through some housekeeping rules. Okay, first of all, if everyone can maintain their phones muted throughout, just to stop any audio interference. Any questions that you have, please feel free to ask them to Chris via the questions pane at the bottom right-hand corner of your screen. We'll also be conducting a couple of polls throughout the webinar just to get your thoughts and feedback on the new legislation. And finally, don't worry if you've missed anything throughout the webinar. We will send a copy of the recording to you via email. Okay, I think that's enough from me. I'll pass over to Chris now, who can take you through the webinar. Chris.
Thanks, Andy. I'll just come. Sorry, as you can see, it's a learning experience for me. Sorry, I was muted there. I was just trying to say that I won't keep this link open throughout the webinar. I'll come back on when we answer questions at the end. But if you do have any questions as we go along, please do pose those via the chat option, and we'll come back to the main agenda each time, and if I can deal with them before I move off the subject, I will. There's actually quite a lot to do, so I'll just close the video link down and move on and talk about the 5 main areas that we're going to look at today. So I'll see you again towards the end of the session. So that's a little bit about me. I head up the team of 9 employment lawyers here at Muckle. We predominantly look after employers across all ranges of business and charitable, third sector and public sector organisations. So what I'm going to try and do is talk to you today about sort of 5 main headings, but to look at the issues that we've covered in the sessions we've done at Durham and in Newcastle for CIPD over the last couple of months. First thing we look at is what's happening with the tribunal system. That's both locally in terms of Newcastle Tribunal and nationally, because the trends are really important and understanding what's going on is a big factor. We'll then look briefly at some of the key changes in case law and what's been happening in terms of new legislation. So we'll look at the legislation first and then the trends from the cases. And then obviously I'm sure a number of you will be aware of the Bear and others and Fulton and others case last week in the Employment Appeals Tribunal and the ramifications of that. So we'll have a look at that before just trying to give some ideas on the future. The aim is to finish by 1 o'clock. If I overrun slightly, I totally appreciate you've got other commitments today, but we will send you a recording at the end if you need to leave before the end, but I will try and make sure that we are done by as close to 1 o'clock as possible. So the first thing we're going to have a look at is the view from the employment tribunals and what's happened over the last couple of years really, which has resulted in a substantial, I suppose, change in the way in which employment claims are dealt with in the UK. So what we've got and what has happened has been a number of things that we'll have a look at in a second, which has resulted in a substantial reduction of employment tribunal claims nationally. So what we see is a 71% reduction between April and June 2013's figures and April and June 2014 figures in terms of employment tribunals. Usually the tribunals expect about 48,000 cases nationally every quarter. The last available statistics show that actually that's reduced to about 8,000 claims, and that is a trend which is continuing. So what we've been trying to think about is why that is and what the factors are. And obviously for the majority of employers that's really good news. There are less claims, there are less issues to have to deal with. But there's been a number of things which are really contributing to that, and which as employers it's helpful to know about and to understand, because you can use those things to your advantage. So the first thing is the 2-year qualifying period for unfair dismissal. This is a change which came about in 2012, so we went back to the 2-year qualifying period. It was previously a year, having been a change which was introduced in 1997 when Tony Blair came into power. But effectively, the first 2 years of employment now is a probationary period. Employees only have the rights under their contract of employment. They have the rights under the Equality Act not to be discriminated against for a protected characteristic, but otherwise you can dismiss an employee if it's not working out without going through a fair process at any stage during the first 2 years of employment. The other thing that's really started to take effect are the changes which came into effect in May this year, which is mandatory now pre-claim conciliation through ACAS before any claim is brought. So before bringing an employment tribunal claim, an employee has to go to ACAS, lodge a request, which is usually by way of a web-based request, for them to get in contact and discuss whether they can help them try and settle the claim before they bring it. Only once they've done that do they get the receipt information that they need to be able to complete the employment tribunal form. And what we're seeing and what we understand from ACAS is that about 1,600 calls a week nationally are going through on that area. So just to get you started, we thought we'd have a quick show of hands or poll to just see what level of pre-claim conciliation experience you've had and whether you've had any claims. So Andy's just going to launch that poll now and leave it open for 10 seconds or so for you to just put your answers in. Partly feel like I should have the countdown music playing now, but hopefully that's given everybody enough time to have a vote, and we'll share those views with people.
Yeah, we're just getting the results in now, Chris. I think everyone is nearly voted, just waiting for the last few people to vote now. Just getting a bit of a countdown. It's just a yes or no vote. And what we can do is we'll share the results once everyone has actually pulled their votes together. I think that's okay. Had about 88% voted there. We'll just share those results.
Thanks, Andy. So that's really probably quite symptomatic of what we found in the open sessions we've done. You know, roughly a third of people have had experience of ACAS since the provisions came in. I was talking to somebody who's in-house with a national retail chain, and they were currently getting about 40 calls a week in relation to that. But there might be specific reasons for that we'll come back to as we go through the sessions. But it obviously shows that is working its way through the system, and gradually the more people we speak to, the more we're finding that people have had experience of dealing with those issues. The other thing that's also probably the biggest factor is around the introduction of employment tribunal fees. So until July last year, 2013, you didn't have to pay anything to bring an employment tribunal claim. Now for an unfair dismissal claim, you have to pay an issue fee of £250 up front unless you qualify for remission, which very few employees do, to be honest. And there's a £950 hearing fee, which has to be paid 8 weeks before the final hearing. So there's effectively a £1,200 cost now to individuals of bringing the claims. I think what we are finding, and what is very much talked about within the legal sort of commentators, is the fact that this is the biggest block on claims coming through. Unison had a hearing before the Court of Appeal in respect of a judicial review on the 21st and 22nd of October. We're expecting the outcome of that shortly, and I think they did have quite a lot of statistical evidence to show that actually it probably is a bar to people seeking justice. Very interesting that a lot of government stuff is now out on Twitter, and I saw a Twitter exchange between Joe Swinson, who's a minister in the Department of Business, Innovation and Skills, and Sean Jones and Casper Glynn, two of the leading employment QCs, where they were asking her, are you going to undertake a review of tribunal fees? And I think she said, we've got no plans currently. I think that they are just waiting and watching what happens. My personal view is that fees are with us to stay, but they're likely to be reduced, and I could see a much smaller fee coming into play if need be. So what's it look like locally? What are we seeing in Newcastle? We attended the Newcastle Employment Tribunal user group meeting, and the last meeting in September, their statistics for August were reasonably shocking actually. In the whole of August they only had 58 claims. They'd normally have 400 plus. and they had 405 multiple claims. By that, it is probably mainly equal pay claims. So Newcastle currently has 24,000 claims on its books. 22,000 of them are equal pay claims working their way through the system. So they only have currently about 2,000 unfair dismissal and other straight employment-related claims proceeding. So anecdotally, we've heard of Newcastle Tribunal not even sitting on certain days, so things are just not going through the tribunal system as it is currently. And what the effects of that, it's important for us as employment lawyers to understand for employers what that means to our clients if they do end up in employment tribunals. And bizarrely, what's happened is that judges are now using the powers that were given to them under the rules, and they've had for a number of years, to actually manage cases and to deal with cases pretty efficiently. They've got more time to consider matters. They are pushing things through. What is quite clear in terms of the new tribunal phase regime is that if you as an employer lose the claim, you can expect to also have to pay the fees that the employee has needed to pay to bring the case to hearing. It's not an absolute obligation, but more often than not, our experience is that the fees are being added on to any judgment, and that's what, again, talking to other lawyers, we're finding is becoming the norm. The other thing that we're finding is the tribunals, as I say, have more time to closely manage cases. So by way of example, they've always had a strikeout power for reasonably poor claims or claims that they just don't think are being run properly by claimants. We had a team meeting a couple of weeks ago where we talked about one specific claim, and the person dealing with it said, I need to write to the tribunal asking for a strikeout. When we reviewed the post that morning, the judge, of his own volition, had written to the claimant and said, I can't actually see the basis of this claim. I'm giving you notice that if you don't provide the information that I need to actually establish whether you've got a valid claim within the next 7 days, I'll strike it out. So he did our job for us to a certain extent, and that claim was subsequently struck out. I think the other thing that we're seeing far more of is that judges are much more likely now to entertain applications for costs if a party succeeds with a tribunal. So it's a claimant matter, not a respondent matter, but we dealt with an individual who had substantial discrimination claims for disability discrimination and unfair dismissal claims to go with them on an insured basis over the summer. One of my partners got an award of £30,000 of costs against the employer in that circumstance. That's very much towards the top end of the national statistics, but it does show that actually judges are willing to use those powers and use them quite draconianly if they feel it's appropriate in the circumstances. So that's the view from the Employment Tribunal. I think we'll move on from there to have a look at what's happened in terms of changes to the law. The normal dates for employment changes are 1st of April and 1st of October every year. That's one of the things that's become, since the coalition government, so that people knew where they stood, that changes would come in at those times. Actually, what we've seen is that the pace of development of legislation has really slowed, and we are getting into now much more sort of bespoke areas. So we knew in April that the flexible working arrangements would change from the 30th of June. Now every employee, regardless of the reason why they wanted, if they wanted to go fishing, to look after their dog, to look after an aged relative, any employee has the right to ask for flexible working. So that's building on the rights that people with childcare responsibilities or people who had in terms of caring for dependent responsibilities had. And what's happened is the simplified procedure that's come in effectively has got rid of the old Department of Business Innovation and Skills 14-day process of write a letter, have a meeting, give a feedback on the meeting. And we are seeing now that there's the right for everybody to ask for flexible working. So by way of example, we have 150 people in our office here. 52 of those people work some form of flexibility, and I think that is just a symptom of where the law is going, and you'll see some trends as we talk through things this afternoon. What you still find is there are 8 legitimate business reasons for turning down a request for flexible working, and one of those reasons, depending on the size and the resources of the employer, might actually be that somebody else has got there sooner and they've got their request in and we can't accommodate you within what remains. So, as I say at the bottom of the slide, we have very few queries on it. There's a good ACAS code of practice, The majority of employers have got used to dealing with these things just face-to-face, and actually the consequences of not being awarded flexible working entitlements, unless you can pin it to indirect sex discrimination around the return, say from maternity leave, is that under the flexible working regulations, the maximum claim is only 8 weeks' pay, capped at £464 per week. So £3,700 approximately to deal with that sort of claim just doesn't make it a viable solution, and we just don't see queries in practice. So that's one change, which is a tinkering, I guess, and is doing what a lot of larger employers were doing anyway. The other one, which sort of snuck through on the 1st of October, was around fathers and partners of pregnant women. It actually gives a statutory right now to attend antenatal appointments on an unpaid basis. That's 2 appointments of up to 6.5 hours each, and an employer can still refuse that if they've got reasonable grounds to do so. But the majority of employers have always allowed that type of leave anyway. What it does is, just for smaller employers, it gives the employees the ability to insist on that if they're not granted it. Another change which came through on the 1st of October, and which sounds scary but actually probably doesn't have many practical consequences, is the power for employment tribunals now to order an equal pay audit where employers lose an equal pay claim. Actually, even in the government's own documentation around this new right, it says that they think it will only apply to 20 cases a year, because equal pay claims don't tend to get to a stage where that final judgment is done and there hasn't been a form of equal pay audit carried out already. An equal pay audit, if it's carried out in the last 3 years, means that this provision wouldn't apply anyway. So it's effectively the tribunal's trying to get equal pay back on the agenda, the government trying to get equal pay on the agenda, but it doesn't have a great deal of teeth. What is probably more interesting is that longer term, especially if we get a change of government, there's always been the provision under Section 78 of the Equality Act which says that employers of 250 or more employees could be required to publish any gender pay information. I think probably that might be more likely. You know, we all know there's a 15% gender pay gap, and actually what's happening in the private sector might push that further forward. So I think what we are watching is private sector equal pay claims. There is currently litigation going on involving ASDA, where you have shop-based shelf stacking staff comparing themselves to warehouse staff who do effectively the operation in reverse. What they're saying is the majority of people in the warehousing operation are men, the majority of people shelf stacking in supermarkets are women, and they're not paid at equivalent rates. And we understand there's 1,000 claims lodged, and probably another up to probably 19,000 in the wings, so potentially ASDA faces 20,000 equal pay claims. I think it's particularly of concern to large multiples and the retailers. Smaller employers, I think there's always been a historical problem with pay information, but I think that equal pay will come back on the agenda as we move through the next general election and into a new era after that. So I think watch this space on equal pay and what's going to happen there. Another change which has been coming for some time, but the process is now in place for it to actually have effect and probably to be rolled out after Christmas, is in relation to a National Health and Work Service. So a contract's been awarded to a company called Health Management Limited, which will run what is basically a call-based scheme originally. It was a benefits agency-driven initiative, but it will help employers in some respects. So basically the aim is to help manage sickness, absence and return to work. And what will happen is if somebody has a sick note for 4 weeks or longer, or they've been off work for 4 weeks or longer, the GP will now have a duty to refer them to the Health and Work Service. They'll get a call and they will effectively be offered support with looking at a return to work. And I think the interesting thing is, you could argue it's state-funded occupational health assessment. Well, it is, but it's not going to replace the type of specific health assessment that is probably needed to deal with long-term ill health or disability issues. But the intention is to try and get people to consider, and it's going to be probably helpful for those type of employees that, say, are off work with stress because it's the work that's causing the stress in the first place. It's going to help have somebody independent talk to them and say, well, actually, is it the job? Can they change the job? And would you be better accepting that the job is what it is and you might need to look for other alternatives? So I think it will aid assessment. It will aid those type of conversations. There is a provision for case assessment for employees with more complex needs, but how that pans out and what will effectively happen sort of remains to be seen. But there will be effectively a trigger point, and if the GP doesn't trigger it, you as an employer will be entitled to trigger it. So again, watch this space. We'll be able to sort of update you as things develop and go through. And then the final thing to just talk about before we come on to shared parental leave, which is the big change for 2015, is about 0 hours contracts. That's become a massive political football. I'm sure a lot of you will have seen the coverage over Ed Miliband's comments over the weekend about Sports Direct and his view that the way in which they employ their workers shows what he, I think, called Victorian practices. So Sports Direct has had some claims in relation to 0 hours workers bringing claims on an indirect sex discrimination basis, because about 80% of the 20,000 workers at Sports Direct are said to be on 0 hours contracts. We know that there's a case potentially going through the High Court which affects them as well in relation to entitlements to bonuses, which are only available to people who are permanent contracts. So they are fighting on a number of fronts in that area. But politically, as I say, it's become a football. No party has said that they will come out and ban 0 hours contracts. And I think the problem we face is that the Pandora's box has really opened on employment relationships and will be really pretty difficult to shut. I think a number of them have talked about focusing on the availability of exclusivity clauses, so saying if you are signed up to a contract with us, you cannot undertake work for anybody else. That might be dealt with, and I think a number of the parties will probably look at that, but actually just banning 0 hours contracts seems to be unlikely. I think if you operate 0 hours contracts, you need to be extremely careful about the management of things like holiday and sick pay entitlements and what the trigger points are, and about looking at access to training and other progression within the organisation. So if it's a part of your organisation, you do need to very carefully think about the management of it and what you will do if a change comes. The consultation that's been going on around 0 hours contracts and the provision of exclusivity closed on the 3rd of November. It's unlikely we'll hear anything, I think, probably until the early part of 2015, and then it is probably a change that's going to run into the general election in May. So it probably is going to be one of those areas that you're just going to have to watch this space on. And then moving on, the big change which has been announced, which comes through on the 5th of April next year, is for parents to be able to share the maternity leave entitlement of the mother effectively. So apart from the compulsory 2 weeks maternity leave that an employee must take after the birth of a child, the remainder will be up for grabs, and provided they qualify, and there are certain qualification criteria which it's probably not helpful to go through at this stage, they will be able to share that leave. And they can do so on a mix and match basis. So the father could take all of it, or they could say we'll take 6 months each and we'll have that off together effectively. Or they can ask for continuous or discontinuous leave. So you can ask for it in blocks. So I'd like next month off, and then I'll come back to work for the next 3 months to finish that project, and then I'd like another 3 months off. It's meant to be extremely flexible, but the flexibility creates quite a lot of complex issues. There is a BIS technical guidance which is about 56 pages long, which has been issued, and there's also a general ACAS guidance, but that doesn't necessarily answer all the questions. Continuous or discontinuous leave, an employer will only have to agree to discontinuous leave if they are willing to agree to it. There's no obligation for them to accept a request for discontinuous leave. But effectively, an employee, provided they give 8 weeks notice, will have a number of bites of the cherry of saying, can you give me that leave on a discontinuous basis? If not, then their continuous leave will start from the date on which they first asked to go off. So it's an area that you need to start thinking about. You need to start looking at your policies in relation to. But as I say, it's meant to be extremely flexible, and it shows the way that the law is going of allowing people to have flexibility between private and work life. But if somebody does move from maternity leave onto shared parental leave, there will now be, rather than the keeping in touch or KIT days, we will have split days, so shared parental leave in touch days, and that would be 20 per parent. And what the government envisages, I think, is that people, say, who work doing the payroll, and it might take them 3 or 4 days a month, might agree that they would do split days where they came back and did that bit to help out, hopefully with the help of agreeing that and then agreeing that they would perhaps get other flexibility in the leave that they're requesting. We're in the process of developing a specific webinar on that. My colleagues Francis and Lisa will be launching that shortly, so if you want details of that, you can sign up at the end to get that, and that will look at some of the more complex arrangements. A couple of things to think about, though, are what is going to happen in terms of payments. It is going to be left very much to the employer to establish, based on declarations, which the guidance notes set out what is required in terms of declarations, to what entitlement the mother and the father are each asking for. There is no requirement for employers to talk to the employer of the other person, and the law doesn't envisage that being a requirement to actually trigger the leave entitlements. But it is something that you have the option to do. How organised small employers will be to deal with that, I think, is going to be a question. An interesting scenario will come with the maternity leave regulations and suitable alternative employment. So if an employee currently is undergoing a redundancy and they're on maternity leave, they effectively have the right to trump anybody else and to be allocated to a role of suitable alternative employment under the maternity leave regs. That arguably will apply to the father as well as the mother, and that will create some interesting questions around what you do if you've got somebody on maternity leave and somebody on shared parental leave who are both in the same redundancy pool. I think that might have been answered by a case which has just been reported called Sefton Borough Council and Wainwright, where they say, well, actually it's got to show that the reason for the discrimination was the reason they weren't allocated for the job, so they probably would end up going through a selection between the two of them for the remaining role. But that is an area which will be tested. Another area which will be tested is probably around enhanced maternity leave. So a male employee would say, well, actually my female colleague is entitled to enhanced maternity leave. I want the parental leave to care for my child. Surely I should get the same as her. Again, it doesn't look like there's a direct sex discrimination case on that basis, but there potentially is an indirect sex discrimination case, and there's a case called Shooter and Ford Motor Company, which is considered something similar around the enhanced paternity leave regs, whereas it said actually in an engineering-based environment we can understand the need to give enhanced maternity rights to allow women to continue to progress through that environment and to try and persuade more women to take up that role than men. But that's the only case I can see. Somebody will bring the case, but I think actually there's still an argument, given the equal pay issues and given the historical issues around the Sex Discrimination Act and the introduction of that type of protection, which means that there must arguably be a public policy ground for saying we actually want to persuade women to take maternity leave entitlement, and I think justification will be something that a lot of employers will be trying to push through. But you can envisage an office environment that might be much more difficult than a heavy engineering environment like Ford. So a number of changes there. It's a complex area, and as I say, we will have a look at that as a webinar. Just before we move on, we thought that was probably quite a good place to just do another poll and get you thinking about things, and just Andy's opened the poll to just say, do you think this will be an issue for your organisation and what level of take-up you think you'll get? So we'll just leave that open for a couple of seconds.
Yeah, if you can all vote there. So is shared parental leave an issue for your organisation? No, yes, you've already dealt with it, or yes, but you haven't dealt with it yet. We'll just wait a couple of seconds for everyone to poll their votes now. The majority of people have voted. And once everyone's voted, we will share the results. Okay, Results are just coming in. Fabulous. It's all working now. Just share those results.
Thanks, Andy. That's interesting that I think a number of you think that it'll actually be quite an issue within your organisation. I think the government's own view is that it'll only be between 2 and 8% on their impact assessment of employers that will actually have to deal with, or employees that will take up this right. So we'll wait and see. I can see it, especially where both parents work for the same organisation, and probably it is public sector and things like NHS trusts that probably have the enhanced rights are going to be the areas where people perhaps are more likely to take it up. But I think it is an area which is going to develop and again is worth keeping an eye on. Right, we'll just move on now to look at the trends from the cases and touch on some of those issues before looking at the holiday pay queries. So, what are we seeing in the Employment Tribunal? Well, actually, as you can imagine, there are less cases, there are less decisions coming through as a result, largely of the reduction in employment tribunals. But what we have seen is an increased trend of cases in relation to contractual issues. And what's important to understand is that employment law has grown up really since the 1970s. Before then, there wasn't a specific area of law. There weren't really solicitors who did this type of work. The employment law is underpinned by a lot of what are effectively 17th century legal principles. So if you think about constructive dismissal, the duty of trust and confidence is something which goes back to the master-servant relationship from apprentices and their masters back in that time. And we still use those rights and obligations quite considerably. And there have been some interesting cases which show the interaction between express terms, so what is written down or what has been agreed directly between an employer and an employee, and what creeps into the relationship to fill a gap. So the Peacock Stores case is an interesting case about custom and practice, and that was about effectively an enhanced redundancy scheme. So during the 1980s and through to 2002-2006, when Peacock had to make redundancies, it did so on the basis of an enhanced scheme. That scheme effectively became notorious, that anybody that worked in Peacocks knew that if you were made redundant, that is what you would get. In 2012, they effectively couldn't afford to keep that enhancement any longer and just tried to pay statutory redundancy pay. And what happened was that Peregrine and a number of others gathered together and took them to the Employment Tribunal and said, well, actually, it's become a matter of our contract. And they succeeded with that because there was no written policy. It had crept into practice. At no stage of Peacock said we were exercising their discretion or giving themselves the ability to argue that it was discretionary, and they were actually bound to make that payment to Peregrine, and it had become a matter of contract for all of those employees. So being careful about things like that you might do on a discretionary basis is important. Building in that as a discretionary right as part of a contract or a policy is important. But there are limits to that. So the law will only allow things to creep in that way, or will imply terms where it is needed to actually operate the term of the contract. And Vision Events is quite a good example of that. So what happened in that case was that Patterson had a flexi working arrangement. Patterson resigned, and before leaving didn't take all of the leave that had accrued under the flexi scheme. The flexi scheme didn't actually say under its rules what that meant, and they argued, well, it's just like holiday leave, isn't it? I should get paid in respect of that. But actually there's a specific legislative provision which says that you should be paid your holiday pay. That isn't there for flexi, and the tribunal said, well, we're not going to imply that term into this arrangement because it's not needed. It is effectively use it or lose it in our view. So we don't need to interpret the contract to actually give effect to that way, and we won't fill the gap that between you didn't have in mind in the first place. So there are, as I say, limits to it. There have been some interesting cases as well, which is really important in this day and age with people doing things by iPhone and by email, and and about binding the employer and entering into contracts that they weren't aware of. Hershaw isn't directly on that point, but it shows the scope that there is for an issue. What happened in Hershaw was that there was a grievance brought in relation to pay bargaining by a group of employees at Sheffield City Council. They said that they should be banded at a band 4, I think it was, rather than a band 3. And what Sheffield City Council did was they got an independent HR consultant in to do the grievance for them, and she found in favour of the employees and effectively gave them a band 5, which was higher than they were asking for, wrote to them on that basis with the outcome and her decision. And the way in which that was formulated, and the fact that she had been given the ability from Sheffield Council to deal with the matter once and for all, she created through that letter a binding obligation on the employer to do that. Sorry, I jumped forward there. Just back on track. So contracts, think about policies. That is still important and still sort of an area where we see cases. What we've also seen as a result of probably the recession and changes over the last few years is situation in relation to post-termination restrictions, with them being far more likely to be enforced, or that at least appearing to be the case from the decided cases that come through. You may or might not know that a post-termination restraint of trade, so saying that somebody will not solicit your clients for 6 months or will not work in a competing business for 3 months, is potentially void as a restraint of trade unless it goes no further than is reasonably necessary to protect the legitimate interests of an employer. So that has always been the important consideration in looking at, well, how far does the restriction go? What does it cover? What does it allow them to do? What can they not do? And obviously, the more draconian the consequences and the more limiting that they are, the less likely they are to be held to be reasonable. The courts have always had a limited ability to change such clauses, which is called a blue pencil test, where they're allowed to use as a judge a blue pencil to actually score things out, so to put a line through things if that still allows the covenant to make sense. But they can't write something in, so if they feel that 12 months is too long a restriction but 3 months would have been okay, they can't cross the 3 months in. And I think what has happened is that we are finding now that judges are saying, well, actually, I will, if I feel the parties are in a position where I need to preserve the status quo pending a speedy trial of a matter, I am more likely to be persuaded to give that form of protection. And that is extending, I think, towards also dealing with some of the problems that we're going to talk about in a second with social networking and other information availability. So in East of England Schools and Palmer worked for East of England Schools, which is a community interest company, in effectively a recruitment business that they had called For Schools, which was recruiting teachers to local East Anglian-based schools. What she tried to argue when she joined a competitor was that candidates in that area showed little loyalty to schools, or the teachers didn't really feel they were bound to one recruitment consultant. And a lot of the information that she was trying to use to compete and to solicit was in the public domain anyway, on LinkedIn and other social networking. And what the judge said was, well, yeah, I accept that is the case and there might not be loyalty, but actually that, in my view, makes it even more reasonable for somebody to be able to say for 6 months you won't use what advantage you've got from soliciting our contacts and schools. So it was upheld against Palmer. But again, there are limits on how far the court is willing to go, and profit is an important sort of limitation on that. So Huggett worked for Profit, which is a software company in developing software, and there was a non-competition clause in his contract which said you will not, in competition with us, do anything which competes with, and the key words were any products you were involved in during the last 12 months. And obviously the problem with that was, we all understand that what they meant was any products which compete with our products, Profit's products, but it didn't say that. It just said any products which you were involved in the last 12 months. Well, that could only have been Profit products, and a judge wasn't willing to actually extend it to the natural meaning. He said, I can use my pencil to score things through, but I can't write those words in, and it's your problem, employer, you got the wording wrong, so I will not enforce it. So that's an important limitation, and it's important I guess, reference point to just keep going back to covenants. And if you're promoting people or moving them into new roles, that's the time to really look at what you need to do. In terms of trends, what the law is really having trouble with is things like social networking, LinkedIn, and the increasing obligation and ability of employers to actually do a lot of their marketing and sales through things like YouTube videos, through building up contacts databases on LinkedIn, through tweeting. The genie, in my view, is really out of the bottle on this. You can contractually try and get people to delete LinkedIn accounts, to delete LinkedIn contacts, and preserving that contractual right might be what you need to do, but you really do need to think about, if that is a part of your organization, getting contractual obligations in place and whether they are truly workable if you are going to prevent people from taking that information or using that information when they leave you. Another area where we've seen quite a lot of changes in relation to disability discrimination. So the Kaltoff case has got a lot of press coverage, but it's a reasonably straightforward case and doesn't really change the law as it stands. Kaltoff was effectively somebody who had, in his view, a disability which was obesity. He had a body mass index of 54 and was a care assistant at a local playgroup in Billund in Denmark. The Danish court referred the question of if is obesity a disability, and what the court said was, well, it potentially could be, but you have to look at the national test for that. And in the UK, it is whether something has a long-term and substantial adverse effect on the ability to carry out normal day-to-day activities. If it does, then obesity can be a disability, but it doesn't necessarily follow that that's the case. And that's the same with conditions such as alcoholism. Alcoholism itself is not a disability, but might be caused by a mental illness, or it might itself give cause to an illness, say, a liver problem or a cancer, which is a disability. So it doesn't really change anything. It hit the headlines, and I can't see disability becoming a protected characteristic under legislation. The other thing to think about with disability is understanding how the law works in this area is different to every other form of disability. If you think about somebody on long-term ill health, they are quite often terminated by reason of being on ill health, so they cannot return to work, and there is an ill health termination which is done under an unfair dismissal process. So you're allowed to directly discriminate against somebody on the basis that they're disabled, which you are not allowed to do in relation to their sex or their race, for example. That is why we have reasonable adjustments as an obligation. So to be allowed to do that, you have to, as an employer, show that you've considered reasonable adjustments before getting to that stage. And that is an active duty on the employer. It's the employer's obligation. It's not enough to sit there in a meeting with an employee and say, have you thought about this? Can we do that? You have to go to the process of finding out what you can do, and obviously the larger the employer, the more you're expected to do. And there's a couple of cases, there's a number of cases coming through there in relation to reasonable adjustments, which actually show the way that we found from our experience that tribunals deal with it, which is in relation to quite often trying to produce the right result for what they feel the circumstances is before them. So in Croft Vet's, Butcher was their receptionist, and there was quite clear evidence that actually the way in which she was treated by the veterinary practice had contributed to her anxiety and stress. And effectively, the tribunal said a failure by the vets to actually contribute towards some counselling, which the occupational health provider that they sent to her said would help alleviate the situation and deal with it, and it cost, I think, just under £1,000. By failing to pay that, they failed to make a duty of reasonable adjustments. I think that's reasonably on the far end of a spectrum. You usually wouldn't be expected to necessarily have to contribute in that sum for a reasonably small employer, but the evidence showed that actually the situation had been created, and I think the tribunal were trying to actually reach the right result for Butcher in the case. In London Borough, the Southwark and Charles, there's almost the reverse consideration made. Charles worked in an office block and had asthma. The office block the only adjustments that were possible in it, given its age, were to look at alternative seating places which Charles didn't want, wasn't prepared to carry out some work from a different location, and the only way they could deal with it was by sitting, by having windows open to have a through flow of air. And the tribunal agreed with the council and said, well, actually, you couldn't do any more in the circumstances, and if Charles wasn't prepared to try some of the options that were available, then it was appropriate for us to, for you to have taken the decisions that you took, and you didn't have a further duty. The cases can really spin on the facts of the cases, and as I say, they're quite often a way to reach the right result. A couple of other short cases have come through as well. The Gallup case is important around medical reports. You cannot just necessarily rely on what a medical advisor says. So if the medical advisor says, as in this case, well, actually, I don't think that the individual you've sent to me is disabled, if you knew that, well, actually, their absences and the extent of the issues that they're facing at work are so substantial, they've gone on for a reasonable period of time, the medical evidence alone will not save you from it potentially being a disability. The tribunals view it as a question of fact in every case. And in the Newport case, they said to the council, you should have known that Gallup was disabled, and actually it was appropriate to reach that decision, and you should have challenged and queried with the occupational health advisor their view, given what you knew when they didn't. But what there is a limitation on reasonable adjustments, and the reasonable adjustment can only be made in relation to the individual employee, and Hainsworth is a good example of that. So Hainsworth worked for the Ministry of Defence in Germany and had a daughter who was disabled. She had Down syndrome, and Hainsworth wanted her daughter to attend a college which was only available in the UK for people with that form of disability. She asked for a transfer back to the UK, and when it was denied, said, well, actually, you're failing to make a reasonable adjustment because I have the duty of care and my daughter suffers from a disability. And they said, well, there's a limitation on the scope of that associated discrimination. It applies if you were bullied or subjected to harassment because of your daughter's disability, but it doesn't apply to the reasonable adjustments heading. You have to have the disability that you're seeking the reasonable adjustment. It's not somebody that you deal with or have a relationship with. And I think probably on a public policy ground I can see that again. There's the blurring of public and private life and work and private life, that actually if that reasonable adjustment was built in as being associative, so if I wanted time off to care for my aged mother because she was disabled, you can see the issues as we all grow older that there are likely to be. So a number of trends there. And the final case around ill health is in relation to Dundee City Council. And effectively all that does is reinforce the fact that it's a question of fact in each case, and each employer has to show an employment tribunal that it could not reasonably wait any longer for an employee to return from long-term ill health. That's the killer question for us as employment lawyers. It's one of those cases that our heart sinks in relation to, where somebody says, have I done enough now to terminate employment? What we tend to do is we tend to have a very clear letter at that stage to the employee or their representative saying, we've done this, we've done that, we've looked at these reasonable adjustments. We can't think of anything more. We can't see you returning in the short or medium term, so we are considering dismissal, and getting that process in play before you actually get to the dismissal stage is probably the best protection. But there will always be a leap of faith in this area, and that's quite often why a lot of ill health dismissals are dealt with under settlement agreement. And then the final couple of cases around trends relate to dismissal procedures and issues. Z&A is an interesting case, but it actually shows that no matter how serious the potential allegations, you still need to go through a proper procedure before you dismiss somebody. So the case involved a school caretaker where the head teacher was provided with information that there had historically, a number of years ago, been allegations raised in relation to sexual offences which weren't investigated or after investigation weren't felt to merit any further investigation by the police. The head teacher was honestly in an invidious position. She had a caretaker that she had these concerns about, but effectively what she needed to have done was to have carried out a fair investigation with that caretaker gone through a fair process to establish whether there was a risk and what that risk was, and actually to fairly assess that risk. And what the caretaker was able to show was that the allegations were made by somebody who was unwell themselves and had been made in circumstances that actually, if you looked at them, probably didn't have the weight that they were given by the school to dismiss. Adigbola is an interesting case as well, which actually helps employees, particularly in discrimination cases, to say, well, actually it's not just a question of looking at the reason why I'm dismissed, but you actually need to go back through the series of warnings that got me there. And the Employment Tribunal has a lot of flexibility, particularly, as I say, in discrimination cases, to look back at those if need be. Then finally, in terms of dismissal procedures, a couple of other things just to be aware of. If you've got individuals who, as a result of the investigation that you're carrying out, might be subject to a criminal investigation, or it is potentially something that could affect their ability to actually carry out their profession, or would result in a recommendation being made to an organisation to bar them from that profession, there is an increased importance of the investigation. You need to make sure that the investigation is thorough, and a tribunal will pick over that more than they might do in a less serious scenario. And there's been a number of cases which are coming through about recordings. So in the Gussain case, Gussain used his iPhone, which he hid under a table, when he left the room during the deliberations, to actually listen and eavesdrop to the deliberations that were made in the disciplinary hearing. The tribunal said, well, actually, we know that you didn't know that was being obtained, but we are entitled to listen to that because in a discrimination case, the employer is guilty until proven innocent, effectively, and it is appropriate for us to know what the considerations were before you dismissed him. So we're finding with iPhones and other technology, the possibility of that type of recording is important. Some of our clients have moved on to having transcripts and keeping recordings themselves. You don't have to, and that can change the nature of the meeting, but that is ultimately one level of protection. Behaving as if what you say might repeat it back is always the best advice. And actually, in the Gussain case, if they had left him in the room and they had gone elsewhere to deliberate, that would not have been an issue. So thinking about how you stage the meetings is important. The final thing to think about is about privilege as well. With the advent of iPhones, mobile telephones, Blackberries, far more of the communications that we have to deal with in litigation now are electronic, text messages, emails, etc. I once had a case where the email chain that was shown to me in relation to an employee that had been made redundant, and her name was Maria, was how do you solve a problem like Maria as the title. That case, because of our duty to disclose the information, whether it helps our case or not, if it's relevant to the case, we have to disclose it. That case effectively collapsed, and we had to settle with her because it showed there was a mindset that this person was going, come what may. So thinking about conversations, thinking about whatever you say might have to be disclosed, if it's written down in an email or other correspondence is important, and understanding if you use independent HR consultants or non-lawyers, what processes and what considerations you make with them, and say restructuring considerations, they are disclosable, so they don't have privileges. They do if you deal with your lawyer. So that's becoming more and more of an issue and something to think about. So it's a whistle-stop tour through the cases really. I'll move on to holiday pay and then quickly address some of the issues around the future. On where it's 5 to 1, I'll move through things as quickly as I can to make sure that we keep as close as we can to time. So, pause for breath. Holiday pay has been probably the biggest headline grabber for employment practitioners and lawyers over the last couple of weeks. So it's now probably 2 weeks since the AT handed down its decision in the case of, sorry, I should have it on the tip of my tongue, Bear and Fulton and others, which I'll come on to in a second. Effectively, the issue has been caused by the way in which we as a nation have implemented the requirements of the EU Working Time Directive. that requires every country in the European Union to give paid holiday entitlement of at least 20 working days, so 4 weeks paid holiday entitlement. As a government, we went further than that when we amended the working time regulations. It's now 5.6 weeks. They effectively added in the 8 days of bank holidays. So we have a difference in terms of how those two types of holidays, there's the 4 weeks working time directive holidays and the additional 1.6 weeks of working time regulations, UK holidays, are brought in. What has happened, there's been a line of cases where if you do not work, or you're not, for example, salaried and work overtime but don't get overtime for it, what you should be paid in relation to a holiday period where you go off after having worked a period of overtime. The normal rule is that under the Employment Rights Act, if you've not got normal hours, your normal week's pay for statutory redundancy pay and other purposes is worked out on an average of the previous 12 weeks. And that is where the issue arises. So what the cases are about is where people are paid overtime, other allowances, shift allowance, travel allowances, or things like commission, whether those payments should be factored into holiday pay. There'd been a case called BAMSI which had said for non-obliged overtime, so if you're not obliged to work overtime, if it's offered to you, you didn't need to include that. So a large majority of employers have gone on that basis for a number of years. But what's happened with the direction of travel of the European Court is that actually it's normal pay for holidays, and because holidays are viewed at European level as a health and safety issue, as effectively sacrosanct, we're seeing that the viewpoint and the direction of travel, as I say, of the European Court is that you should effectively get paid what you would be paid on holiday, what you would have been paid if you were in work. So the decision on the 8th of November in Bear has actually just maintained that direction of travel, but the judge has effectively, I think, tried to manoeuvre a path through which gives something to all of the parties. So there are a number of areas which are covered, but what the case involved was about guaranteed, so that's overtime which has to be worked if offered, and it also covered non-guaranteed overtime, which is there's no obligation to offer it, but if it is offered you must work it, which were the requirements of the employees in the particular cases before it. Arguably there isn't a decision on what happens with voluntary overtime, but I think quite clearly from my perspective the direction of travel is that it is normal pay, so actually even if the overtime is voluntary you should be considering factoring that into what you pay people. What the judge has tried to do, so he gave that to the employees, what he's tried to do to limit the exposure to the employers and the UK government was effectively say that actually the way in which this should be backdated is that if there has been a 3-month gap between the unlawful deductions, so not being paid the right working time directive holiday the first 4 weeks, and then having that right again, you will not be able to backdate your claim beyond any 3-month gaps. You must bring the claim within the last of those unlawful deductions. And if you think about the majority of us, if we have a January to January holiday year, what the judge said was you have no right as an employee to choose which holiday counts as the European bit and which counts as the UK bit. The European bit, 4 weeks is the first part of the year, the UK bit is the second part of the year, and effectively the majority of us will have taken the European bit the first 4 weeks probably by the end of August. So actually there are probably a number of employees who are already out of time for claims historically, and claims probably only go back to the beginning of the current holiday year. But we're trying to work that out. It depends on the circumstances of each case, and what you will find is that individuals sitting next to each other will potentially have different levels of claims. There's still a substantial amount of uncertainty, and there's another case called Locke which is going back to the Employment Tribunal, which is about commission entitlements in January. But it looks like if you can show a payment is intrinsically linked to you being at work, that you will be entitled as an employee to argue for that for holiday pay. What I said is that further appeal is likely. I actually was talking to one of the barristers involved in one of these cases a couple of days ago, and he said for specific reasons there's potentially a likelihood that the appeals might not follow, because there seems to be a likelihood that if the trade unions have got what those members want, they might not pursue it on a wider issue. But again, it's watch this space. It's in very early days, really. So we thought that was probably a good stage to just say, before we reached into it, whether you feel that that's likely to be an issue for you. And Andy's, I think that the poll that we were going to launch is actually the poll that was on previously. So that's.
We've launched that poll to say, what is the take-up going to be in your organisation? Let me have a look. We've got less than 10%, 10% to 30%, 30% to 50%, or 50% or more. Let me just close that poll.
Thanks, Andy. That's quite interesting in terms of it shows that I suppose a number of you don't think it's actually going to be a factor for you. I think, as I say, it's very early days in terms of what we're going to do, and we've got a live question and answers document again if you want to sign up to our updates about where we're answering questions as and when they come in. But some of the things we're talking about clients to do currently is just looking at the payments, the supplements, the allowances that you pay to your staff. Again, looking at each employee on a case-by-case basis, as I say, a number of the cases will be out of time, and even in the BEAR and the other cases, there will be a number of employees, depending on when they put their claims on, who will be out of time in relation to what the backdating of the pays be. And then the question will be, if you have to make change, is whether you actually wait and see what happens, or whether you do it now. My personal view is that actually probably now is the time to address it. As I say, the direction of travel at European level is it's normal pay for holidays, and at least to the extent of the first 4 weeks of the holiday entitlement, getting it right means that you are not building historical claims. And actually, if the 1st of January is when your payroll is when your holiday year starts, that is a good time to actually think about the change, because obviously the backdating would probably not go back any further than the 1st of January 2014. I think the good news for employers is it's not an area where claims farmers are likely to move into, because the cases are reasonably difficult to bring. You can't bring just one test case that covers everybody, and the amounts at stake are reasonably small. But I think particularly in unionised backgrounds, we are seeing unions trying to negotiate perhaps a global settlement as part of a general arrangement which moves into dealing with holiday pay on the basis of the cases. So that's holiday pay, and as I say, it's watch this space, and again we will be updating clients, and I'm sure you will be getting updates from a number of sources on that area as things develop. What about the future? We thought it was useful just to spend a couple of minutes before we finish just looking at where we see things going. A couple of the things that I've talked about already. Pace of legislative change is slowing. It's hard to think of other areas where we can get into change, and I think what you will see is probably a scaling back of areas. My personal view is that equal pay will come back onto the agenda, particularly if we get a Labour government after May 2015. Very few early political party pledges of any real note. There are the few around 0 hours contracts, and as I say, the majority of them are about banning exclusivity of those arrangements. There probably is a likelihood of further overhaul of the employment tribunal system. Chuka Umunna, who's the government's the shadow spokesman for the Labour Party on employment law and is an employment barrister himself, has said that the system probably needs a root and branch reform, and that might be twinned with fees. And potentially, I suppose, if we get a very strong Conservative government after the election, they might go back to the Beecroft report, where one of the proposals was to remove unfair dismissal as a concept entirely, but that probably might be a step too far. But that could be a factor, as could be, and yet fallout if we were to leave the European Union as well. But it just shows how what we do as employers and what we do as employment practitioners is actually affected quite often by substantial political doctrine changes. What is quite clear to me is that the courts are grappling with technological advances, as we saw in terms of LinkedIn, in terms of privilege. The civil courts now have e-disclosure obligations. I think it's only a matter of time before in the Employment Tribunal we are asked and required to carry out searches of emails and other sources of that sort of information. So being aware of that and knowing what you might have to disclose extends quite widely is important for you. And then the long term, I think I've talked a couple of times this morning about the blurring of work and private life. If you see France and Germany, they're talking in those countries about effectively forcing people to switch off from work. I don't think that's happening. I think there's a generational change where lots of younger workers want to effectively work flexibly and do their work when they choose, and I think if you can grapple with that and deal with that, you're going to be able to set yourself apart as an employer. But actually it creates quite a lot of legal considerations around benefits, around hours, around sick pay, holiday pay that just need factoring through as you make your decisions. We are an increasingly flexible workforce. We will have to work longer, and I think the first point there is the point that really is, from my perspective, the elephant in the room, is how we deal sympathetically with retirement considerations. I think it's easy in an office-based environment, in a professional environment. The difficulty we are facing is dealing with individuals who are perhaps approaching late 60s and do a very physical job and are no longer capable physically of doing so. You then, as the employer, have a process to manage with the risk of an age discrimination claim around that process, and quite a lot of employers in that situation are dealing with things under a settlement agreement, which actually doesn't sit right with having to pay somebody effectively something to retire. But that is an area which I think we're all going to grapple with over the next 20 or so years as we all approach retirement and have to work far longer than we had probably all planned when we started work. So if there's any questions, I'll deal with those now. I'll come back online. And are there anything, Andy, that come in?
No up-to-date questions as yet.
Well, that's fine. So if anybody has any questions, please, feel free to pose them. If it's helpful to deal with them offline, please, my contact details are there. The other option that's available is always to just contact us via any of the other forums that are available. But otherwise, I hope you've found it of some use. I'm sorry I've overshot by 5 minutes or so, and thank you for bearing with us as we've sort of had a couple of little glitches. But thanks, and I hope you found your value, and look forward to hopefully speaking to you again soon. Thank you very much.